I think now, Rob, we're very happy to take any questions that you might have on the legislation.
How many dangerous sex offenders have you allowed out of prison that this legislation is the target?
Well, that's a, with respect, rather silly question. I don't let people out of prison. People who are in prison for sex offenders do two things. They are either released at the end of their term, about which fact I can do and the government can do nothing because we have a separate judicial system. There is an act in place called the Dangerous Sex Offenders Act. That act allows the state government, through the auspices of the DPP, to make an extraordinary application, and that is to hold someone in prison after the date at which their term of imprisonment has formally ended. Now, that is an extraordinary thing to be able to do. This government has that legislation available to it, and we use it regularly. But when you ask me how many sex offenders have I let out of prison, the answer to that question is none.
Well, in the dangerous category, isn't that the point? Why do you need this extra legislation when you already have the power to keep in prison and not society those that are dangerous?
We have the power to make an application to the court for a judge under the separation of powers to make a judicial decision to keep someone in prison if they're at a high level of dangerousness beyond the term of their finite sentence. Now, that is an extraordinary power. We think an appropriate one, but the unfortunate reality is that many people serve very long sentences for serious offences, sex offences, offences against children, and eventually they are released. And that is an unfortunate inevitability unless we are to live in a society where people are imprisoned forever for a range of offences. That's not the society we live in. So it's incumbent on the government to devise other schemes to try and enhance the protection of children. That's what the dangerous sex offender legislation and orders are about, and that's what this legislation is about.
So who actually decides then whose picture goes up on this website?
The rules in the legislation are very clear. So, if you like, there's a pool of people who potentially go up. In Tier 1, as Rob's described, Tier 1 are all the people who are presently appearing on the ANCOR register, the Child Offender Sex Register, but who have breached their reporting requirements. And as Rob has said, at any given point in time, there's somewhere between 6 and 12 of those types of people. And significant detail about those people will be put on the register, and that will be open for anyone to look on the website and find out. The second tier are people who have had to report under the state legislation and who have committed one offence and have gone on the register and then committed a second and serious offence. Plus, dangerous sex offenders, they will also be potentially in that category. But of that pool, the Minister and the Police Commissioner will always retain the discretion to not have someone on the register if there is a very exceptional and cogent reason why that might be the case. If the risk factors to the community are higher from having the information available than they are from not having the information available. The third tier is anyone who is on the ANCOR register potentially can be the subject of an application from a single mother or from parents who are suspicious about a tutor or a boyfriend or a de facto or whoever it might be. Based on a system that's used in the United Kingdom, they can make an application in on the website and ask this simple question: is the person that I'm concerned about on the Child Offender Sex Register? And if they are, we will send out a police liaison unit to convey that information and do it in a safe and sensible and cautious way.
Do you accept some community members will use this information to take matters into their own hands?
No, I don't. And when we look at the way in which this has been used in the United States and the UK, we have been unable to find serious examples of that occurring. For instance, in the UK with the Tier 3 of the system, it was run as a trial in several police boroughs. There were hundreds of applications. In 21 instances in one of the police boroughs, the answer to the question asked was yes. That person that you are concerned about is on the Child Sex Offender Register. And that is very important information, I think, for a parent to be able to access and have a positive response to. There was never any misuse, and there are significant precautionary parts of this legislation. To make an application under Tier 2 or Tier 3, you will have to give your details, your reason for making the application, give an acknowledgement through the web-based system that you understand that there are serious penalties in place for the breach of for using the information in an inappropriate way, So there are significant safeguards. This is a fairly sophisticated model.
Can you just spell out what those safeguards are in terms of what the penalty is? I know you said it was
Yeah,
like
of course.
penalties, but
The same as mimicking the penalties that are for the ANCOR register. If you misuse information which you have been given by the processes of this legislation and the website, the potential maximum is a 5-year term of imprisonment. If you misuse the information and republish it with the intention of causing harm to another party or bringing about vigilante behaviour or things of that nature, then the potential maximum penalty is 10 years imprisonment. And again, they are the same penalties that presently exist under the ANCOR legislation.
So if someone gets this information and, for instance, puts it on Facebook, they could be looking at it?
Well, that would be very, very unwise, and that would at first instance be an act subject potentially to a fairly serious criminal penalty. But in the process of applying, all this information will be given to the parent or guardian who is applying. It'll be spelt out. People will acknowledge that they understand what they can and can't do with the information. And the information is about enhancing a parent's ability to protect their own child. The information is not for the purpose, evidently, of taking the law into your own hands. And what we've found in the jurisdictions that have similar systems is people have used the information for the purposes of protecting their children and have not used the information to go and do stupid things.
it's such an emotional issue, though. If you're in your first year where you've got these people that have breached, they could so easily be recognised. What's to stop people congregating around their house and trying to kick them out?
With respect to Tier 1, we hope they do get recognised. And we hope that the people who recognise them, as they'll be informed they should do on the website, inform the police immediately. Because with respect to Tier 1, they are the people who should be reporting because they are serious sexual offenders, but who are not. That is to say, their whereabouts are now no longer certain. And very unfortunately, there are a small core group of those people. So we would very much hope that when this information goes live, we find where those people are. With respect to Tier 2, that will be by individual application. What people will get with respect to Tier 2 is a photograph of the person, not their name or address, but a photograph of the person or persons who are the more serious sexual offenders who live in the postcode of the applicant or adjoining postcodes. Now, what we've said is that is a good piece of information to have to be able to allow a parent or guardian to engage in protective behaviours, but it's obviously not going to be enough information to turn up at the doorstep of someone because you don't know what their address is. That's not information which is available through the website.
But they could still be, like, their address could easily be located. People talk at schools and whatnot. Parents share information, obviously.
Look, it's not impossible. But if you plug onto a website and you are given the photos of 4 or 7 people who are serious repeat sex offenders, who live in adjoining districts to you, that information is being provided so that if you see those people, you can either report it to police or avoid them as and when necessary. Now, if people somehow, through sleuth-like investigative practices, manage to track down the address of those people and then engage in behaviour which is contrary to the Act, there are potential penalties. What we have found in other jurisdictions is people don't do that. People log on to get the pictures of these people because they're concerned about individuals that they encounter down at a park or in a public place, and they want to know whether or not they should be concerned about those individuals. So what we've found in all the other jurisdictions is that the parents and the guardians who seek the information use the information properly. And we're confident that'll happen here.
What information will you provide on these offenders, and are you going to be consulting the victims or their families before they're released publicly, that information?
Well, in Tier 1, the information will be a lot of information. Photographs, names, aliases, last known addresses, because these are people we want to locate.
And they're crying?
Oh yes. I mean, there's going to be a lot of information. With respect to the second tier, significantly less information. By virtue of the fact that they appear, their picture appears on this register, the parent or guardian will know that these are people who've committed very serious offences. We will not be stipulating the offence. All that you will get on Tier 2 is information which is visual, which allows a parent to engage in protective behaviours in public places or in their neighbourhoods. With respect to Tier 3, the person applies for the information. So they obviously have a lot of personal information about the person with respect to whom they are applying. The person is a de facto or a piano tutor or whoever it might be. In those instances, if the answer is yes, this person is on the register, that information will be conveyed privately and in person by police officers of Western Australia, and the information will be sufficient to allow the parent or guardian to make decisions about how they supervise and protect their child.
Yeah, but will the victims of the crimes that have caused these people to be put up on a website be told that it's happening?
The victims of crimes, no, but the persons themselves, yes. There will be a procedural fairness natural justice process where a person whose photo is going to be shown under Tier 2 or who may be identified as a person on a register in Tier 3 will be notified of the fact that they are to be the subject of this notification, and that's simply a requirement of procedural fairness.
Can they seek redress or?
Well, they can object, but ultimately the discretion is in the hands of the police minister and the police commissioner.
What happens with people who've committed repeat offences against members of their own family? So in the current system, they're pretty much anonymous to protect the victim. What happens here? Would they end up on the website? Is there any chance their children might be vulnerable to getting teased?
Under the Offender Reporting Act that we have in this state at the moment, there is no distinction drawn between someone who has committed a sexual offence against a relative to someone who has committed one against a stranger. If you commit a serious sexual offence and then go on the register and commit another one, then you will sit inside that pool of people who potentially can have their photograph displayed to allow parents to engage in protective behaviour with respect to their children.
When do you want this operational by?
Well, first of all, let's get the legislation passed. We want to try and get the legislation through as swiftly as possible. I think the website's going to take some time to design and have up and running. Rob might need to be able to answer that question.
Yes, look, just to answer the previous question, the Commissioner will retain the discretion as to whether or not somebody should go onto the website that will be available to the public or to parents and guardians. And of course, he will take into account the victims of those perpetrators. So he will have that discretion, as he does in many other aspects. In relation to the website's already being designed, and we would hope that it will be up and running in the first half of next year.
So if a family was to come to the government or the police commissioner and say, it will affect us if you name my former husband, partner, whoever, who is the offender, what would happen then?
Well, once again, that would be at the discretion of the police commissioner, and in some cases, the commissioner and myself as police minister.
You would expect that would be enough to stop that person being named?
Or? Well, it's quite possible, yes.
Certain suburbs and communities have a concentration of, for example, a particular ethnic group with a lot having the same surname and similar first names as well, or identical first names. And sometimes due to ignorance with identifying different cultures or colour of the skin, do you risk getting confused as to who the offender is when people have similar names?
No, I don't think so, because Tier 1 will be the only one where you will see an offender's name published on Tier 1. That could be half a dozen people at any one time. Tier 2 will not have the offender's name at all. All you will access under Tier 2 will be a picture of a repeat sexual offender who is in your postcode or the adjoining postcodes. It will simply have a photo of that person, no other details at all. So it won't be a question of names. In Tier 3, that is a much more individual way of finding out whether somebody is a reportable sex offender that has unsupervised access to your children. So it's much more personal, and that's between the applicant and the police, the Sexual Assault Management Squad, and of course the person, whether or not they are a sexual offender.
Are you hopeful this legislation will get through?
Look, I would be very surprised if any Member of Parliament would vote against legislation that is absolutely designed to try and protect children in our community.
As this has a punitive effect on the offender, do you think judges will now take it into account in sentencing?
No, I don't accept that it is a punitive effect on offenders. I think these people have committed more than one serious sexual crime against a child, and in other cases against adults, but predominantly for children. And I believe that that the public have a right to know, parents have a right to know, if their child should come across those people. Under Tier 2, if you get the pictures up of those people in your postcodes and adjoining postcodes, and you actually see that person attending a local playground, a park, which may well be in contravention of their reporting orders, that you can then report them to the police, and the police would then check up on that. The whole thing is designed to try and protect our children.
It seems a bit surprising that the police have lost track of so many serious sex offenders. How do you explain that? That
Well,
just running around without anyone knowing they're there.
No, out of 2,500 on the register in WA, the ANCOR register, there's 2,500. If you've got half a dozen that suddenly go missing, for whatever reason, I wouldn't call that a lot, but that half a dozen are serious sex offenders, and we want to know where they are. And the mere fact that they are not reporting to police, as they have to under the orders that are set down, they are guilty of another offence, which could put them in prison for 2 years, as the legislation stands at the moment.
The case that inspired you to pursue this legislation, can you just talk us through that? Like, what was it about that case specifically that led to this?
Oh, look, I think, the tragic death of Sophia, I think not only affected people in WA, but I think it affected them worldwide. I know that for a fact. And any parent, grandparent, auntie or uncle would be devastated to know that somebody as lovely as Sophia would come to such a tragic end. And I think from that day I had a personal commitment to try and do whatever I could. That's why I set up a parliamentary committee to try and look into how we can best deal with those people who commit sexual assaults against particularly children.
Legislation have been able to help in that instance, though?
It's difficult to say. You can never say for sure. As it turned out, no. But if Dante Arthurs had been found guilty of the previous offence, then it may have, because he would have been on the sexual offenders register and he would have had reporting obligations. And so in that instance it may have, but it's very, very difficult to say for certain.
And can you just respond to those claims from libertarian groups about this leading to vigilantism? What's your response to that?
Look, I don't believe it will lead to vigilante.
Sorry, you've just dropped your voice a lot.
Sorry, I've got a bit of a chest infection at the moment, so I apologise. Look, I don't believe that this will lead to any vigilante action. I think, the general public in WA are pretty responsible. And to the civil libertarians, I say, we as a government, we as a Liberal Party, we are more interested in the rights of victims, and in this case children, innocent children, than we are in any rights that may be afforded to repeat dangerous sexual offenders.
Robin, can I just throw a question to you? The statistics that you put forward, I find really difficult to believe. Can you explain where they came from? The 1 in 4 and the 1 in 6?
That is well known, and if you ask, I went to a lunch at Parkerville the other day, and those statistics were presented again. When you do as much research as what I've done, you know that there is 1 in 4 girls and 1 in 6 boys. That is horrific, and parents need to understand that 90% of the offenders are known to their victims. 90%, and some of those would not have been convicted of an offence as yet, but some of them would be repeat sex offenders.
Can I just add one quick thing? The two penalties, I did say 5 and 10, it's actually 2 and 10. Sorry, so 2 years for misusing information. The maximum 10-year penalty is if you misuse the information with intent to engage in vigilante action or do harm to a third person. And just also with respect to your question, the way that this legislation is structured should make no difference whatsoever to the process of sentencing in the first instance. You've described this as punitive. Already this information is stored and used, and this won't have a mitigating aspect in sentencing. That simply won't occur, and the way that the legislation's been drafted is so that it's to ensure that that won't occur. And just to confirm that Rob's quite right, there's no distinction between intrafamilial or extrafamilial sex offending to get on the reporting system that we have at the moment, but the nature of the sex offence and submissions by both victims as well as the person themselves, are going to be things that the Police Commissioner and the Minister can take into account as a matter of their discretion. But ultimately the discretion lies with the Minister and the Police Commissioner.
If the family doesn't know that that's going to be happening, how could they be in a position to put up a submission?
Because we will go through the process of ensuring that the appropriate people are notified. Obviously with Tier 1 that process doesn't exist, but with Tier 2 and Tier 3 we know the persons who are going to be potentially placed on the register in Tier 2, or know the persons who will be the subject of the information going back to the individual applicant in Tier 3.